Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3227, United States of America versus Kenneth Joseph Owen Thomas, appellant. Mr. Roots for the appellant, Mr. Andrews for the appellate.
Good morning, Mr. Roots.
Good morning. Thank you, Your Honor.
Before we proceed, if you are wearing a hat and it's not a religious headgear, then please remove it. All right, please proceed.
Thank you, Your Honor. May it please this honorable court, I represent Mr. Kenneth Joseph Thomas. He is in federal prison serving almost 5 years for a case that really should never have been more than a disorderly conduct case. He was convicted of 4 counts. He was actually charged with 5 counts of assault under 18 U.S. Code Section 111A and some other charges. There are so many reversible errors in this case that it's almost, I guess, appropriate for me to just talk about the totality of the trial being so lopsided, with the court's rulings so favoring the prosecution, that it was essentially it was a trial in name. The defense was constantly warned and threatened. In fact, both of us lawyers at this trial were warned by the judge, and we were under the impression we were going to be arrested at the end of the trial or held in contempt or submitted to the bar for discipline for if we advocated too zealously, if we crossed a line. And we were warned several times by the judge about this. This totally chilled the atmosphere of our advocacy in that trial. I'll just highlight a few things because there's so many different reversible errors in this case. The denial of a missing witness instruction. So this was a case where Mr. Thomas was convicted of assaulting 4 officers, 2 of whom never even showed up to testify. They weren't there. But officers came to testify who were next to them or nearby, and those officers provided the evidence for these so-called assaults. We asked for a missing witness instruction so that this is an ancient rule of evidence, that where one side really has control of its witnesses and has the witnesses would obviously be on one side, and one side is not producing them or important evidence, that the jury is free to infer. They don't have to, but they're free to infer that those witnesses probably would have provided some adverse testimony. Now, the judge in this case, Judge Friedrich, said, well, we, the defense, in our case in chief, we're free to call. We don't need a missing witness instruction because we could call these witnesses in our case in chief. Now, these are the so-called victims alleged, the victims of Mr. Thomas. Just think of how preposterous this rule would be, that the defense has a burden to call his alleged victims in his case in chief, as opposed to being able to point out the government failed to call those witnesses. These are the most important, these are the victims of the crime. The court held basically that—
Mr. Roots, I've seen and I've tried lots of cases where the victim didn't testify, domestic violence cases, all sorts of cases. Never seen or received a missing witness instruction on a single one of those.
Sure. Let's put it this way. We all are familiar with this statute, 18 U.S. Code 111A. It has these 6 verbs: assaulting, comma, resisting, comma, opposing, comma, I think impeding, comma, intimidating. It's probably absolutely appropriate for other people, not the victim, to take the stand and testify about an assault, let's say from 100 feet away, a kick, a hit, a strike of some kind, or you say, as you say, a domestic violence case, injuries. That's perfectly appropriate. But in a case where obviously the jury found one of those other verbs, opposing or interfering with, one of those other verbs, and it's clear in this case the jury only found that. There were misdemeanor counts that the jury acquitted on. There was a misdemeanor called committing an act of violence at the U.S. Capitol. The jury totally acquitted. That means the jury understood there was no violence by Mr. Thomas. So it would have been one of those other verbs, opposing, interfering with, whatever. And I think we all would agree that as we travel down those verbs toward the end, we start with assault and it gets to opposing, intimidating, interfering with. The subjective perspective of the victim becomes more important. And in this case, we don't have the victims. And I think the jury should have been allowed to infer, wait a minute, this is very strange. The government is saying that there were these 2 assault victims. They never showed up. What's going on here? This was, if ever, in this district, in this circuit, the missing witness doctrine is dead right now. And it's an ancient rule of evidence and it should be revived. And this is the absolute greatest case to revive it in because frankly, in no other case is it a better teed up issue. The district judge just said, oh, you can call them yourselves, you're free. Think of how tactically stupid and foolish it would be for a defense lawyer to call an adverse witness in front of a live jury when you don't know what the witness is going to say. It's just preposterous. If ever there were a case to revive the missing witness doctrine, it is this case.
Could I ask you about assault? I am not necessarily persuaded that all of these counts involved assault, but 111 is not limited to assault. As you say, there are a string of verbs on down to and including interference. So the counts where there's no running towards the officers or hitting the officers, if someone is just dug in, passively resisting, or making contact in a way that doesn't threaten physical injury, 111 covers all of that.
Sure, but this, I think the fact that it's a felony conviction, whereas it really should be misdemeanor disorderly conduct.
Felony is triggered by the intent to commit the other offense, and he was convicted of the civil disorder.
Yeah, but the judge imposed such a lopsided sort of set of restrictions that Mr. Thomas was essentially compelled to take the stand. He was forced to take the stand because the judge denied the expert witness on use of force for us.
Sorry, just hang with me for a second on assault versus interference.
Yeah.
Why aren't all these counts comfortably forcible interference?
Well, because it is
with intent to commit the civil disorder offense.
Let's put it this way. It is in the context of a civil disobedience. So this is very common, as we all know, in mass demonstrations. Well, civil disobedience is a recognized First Amendment thing where someone does a sit down or a die in or a sit in and expects that officers are going to come, as they do, they always do, with lots of riot gear and body armor and shields, and that they will be pushed away, pushed out, ultimately probably arrested for misdemeanors. We've all seen this 1,000 times. That was Mr. Thomas's defense, was that he was passively resisting. He was committing, if anything, a misdemeanor, expecting probably, hey, a misdemeanor charge. He's sitting in federal prison.
But on sufficiency of the evidence, we don't rule whether a jury could have believed or bought or been persuaded by that defense. We review whether there's no reasonable jury that could find, taking all the evidence in the light most favorable to the government, the elements beyond a reasonable doubt.
Yes, the most important word in the statute is force. So Mr. Thomas was convicted of this felony charge, forcefully intimidating, forcefully opposing, when in fact, there's not sufficient evidence for that.
Well, he's on videotape yelling, hold the line, and locking arms with people and pushing back and forth. That's not force?
It is passive resistance in the line of all
reasonable
the
juror couldn't find that that's force?
It certainly was not aggressive force. It was not offensive force. We all know that scene. At the end of the day, this was 4 o'clock in the afternoon. Basically, the officers had come with sufficient numbers to retake the Capitol grounds, and they were pushing all the protesters out and away to the grounds and out into the city. And Mr. Thomas was there with so many others. who were trying to do whatever they could.
How
Maybe
did the protesters take the Capitol if the officers had to retake it? Did they take it by force?
Mr. Thomas certainly did not. He was not among the initial, he did not breach the Capitol. He came later. I will sit down and reserve my,
All right, we'll give you some time on rebuttal.
thank you so much.
Mr. Andrews?
Good morning, and may it please the court. Peter Andrews on behalf of the United States. Mr. Thomas received a fair trial. His convictions were supported by sufficient evidence, and any sentencing error was harmless. So this court should affirm his convictions and sentence. I'll turn first to the assault issue that you were discussing with Mr. Thomas's counsel. There was sufficient evidence to show that Mr. Thomas committed each of the assaults he was charged with. He used some quantum of force in each of the interactions with the officer, which is enough to satisfy the forcibly requirement of the statute. Mr. Thomas makes the argument in his reply brief that the term forcibly requires violent force. That is not correct. The statute only requires some amount of forcible contact mirroring the requirements of common law assault and battery. Courts have rejected the argument that 111 requires violence. And the case he relies on, which is United States versus Johnson, is just not on point because Johnson is about interpreting the phrase physical force within the context of the statutory category violent felonies. So the Supreme Court's logic in Johnson follows from the use of the term violent in the statute. And there's no reason to import that same logic here into 111, where violence is not mentioned in the statute. As the videos show, Mr. Thomas, in each of the interactions with law enforcement, at a minimum made physical contact with them or was acting with the intent to commit another felony, civil disorder. So there was sufficient evidence supporting each of his convictions. I'll also just briefly touch on the missing witness issue raised by Mr. Thomas's counsel. The missing witness instruction is appropriate when there's an inference to be drawn that the government did something wrong by not calling the witness. That inference is not appropriate here. Each of the assaults was captured on video, and the witnesses were within Mr. Thomas's ken to call if he believed that they would help elucidate the transaction in his favor. They were known to him. So this is unlike the missing witness cases where, for example, you have a confidential informant who's uniquely within the government's ability to control. There was no reason for the district court to give a missing witness instruction here, and she correctly declined to give one.
Does the witness have to be uniquely within the government's control in order for defense to be entitled to the instruction? And have we ever said that?
Yeah, so the rule is that the witness has to be peculiarly or uniquely in the government's control. So there has to be some reason why the defendant is unable to identify or call that witness. So this comes up in informant cases and confidential or cases where the government is the only person who knows where to track down a witness so they can be called for trial. It doesn't extend to a case where the officer involved in the transaction is absolutely known. He's on the witness list. They know what agency he works for. There's no reason why Mr. Thomas couldn't have called in this case. If there are no further questions from the panel on any of the other issues, we'd ask that this court affirm Mr. Thomas's convictions and sentence. Thank you.
Thank you. Mr. Roots, I believe you only had 24 seconds, but we'll give you 2 minutes.
Okay, thank you. The government just stood here and said that a missing witness instruction would have suggested that the government did something wrong. The government did something wrong in this case. It falsely convicted an innocent man of a crime, several crimes that he did not commit. That is something wrong. And a jury has a right to be informed of this principle of evidence, which they can reject or accept, that they can draw an adverse inference when a most important witness in a trial is not called by the government. The very victim, the so-called victim of the assaults are not called. And so I just submit they are doing something wrong, and the jury had a right to be, to understand this. And I'll just add that all four officers in which Mr. Thomas was convicted of 111A, all of them barely remembered Mr. Thomas at all. They didn't write any reports saying they'd been assaulted, intimidated, coerced, anything by Mr. Thomas. No written reports, didn't remember. They only remembered once the government showed them videos. Oh yeah, there's that guy there. They expressed fear, but it was fear of the crowd, the moment, the riot, essentially. And with that, I thank you so much, Your Honors.
Thank you. We'll take the case under advisement.
Oh, just kidding. Okay. Sure. Case number 23-5254, Twin Metals Minnesota LLC and Franconia Minerals US LLC appellants versus United States of America et al. Ms. Blatt for the appellants, Ms. Jaffe for the appellees, Ms. McGrath for the intervenor appellees.
Morning, Ms. Blatt.
Good morning, and thank you, and may it please the court, Lisa Blatt for the appellants. With the court's permission, I would like to address two post-briefing developments that we think suggest that the court should hold the appeal in abeyance, just based on judicial economy. First, we're obviously on the eve of a new administration that has publicly, enthusiastically expressed support for this project, and we think that that government could immediately take new action that would moot the issues on appeal. And second, there's the flurry of 28 J letters that have been filed in the last, I think, 10 days or so. So on December 19th, the the Interior Department, the government informed this court and us for the first time that Interior sought the Forest Service's view on Twin Metals preference rights, lease applications, and Forest Service then responded expressing their opposition to the project. On Friday, we filed our own 28J letter that informed the court that we have since administratively appealed that Forest Service action. And although this court, we think, could decide all the issues on appeal today or now, and without regard to the Forest Service's view, at least the preference rights lease applications involve complicated questions, certainly a first impression that the court may want to wish and wait if it doesn't have to decide those questions.
How would resolution of the administrative appeal that you recently filed moot this case?
Well, I don't think it would moot it, but it certainly could affect it because the government is relying on the Forest Service lack of consent, and obviously if that's appealed. But I think more importantly, and this dovetails with both the timing of the letter that it was filed, 3 years after the Interior Department declined the applications 3 years ago. This was not the basis, and it came on the eve of oral argument. Strikes to us as not only grotesquely post hoc, but even smacks of possible political issues. And Monday, a new administration comes in. And so I think it just dovetails with that. To be sure, it does not, you can decide the question simply on Chenery Calcutt grounds because the Interior Department doesn't even cite the Forest Service letter. So you can just ignore the Forest Service views. It doesn't prohibit you from deciding it. It's just a question of judicial efficiency. So it's totally obviously within your discretion. And I'm going to start with the jurisdictional issue, but when we get into the preference right lease applications, we can walk through it and you'll see you don't have to even look at what the Forest Service did.
The administrative appeal goes only to the PLRA applications, right?
That's correct. That's correct. Not the lease renewal. So I'll start with the jurisdictional issue. This is involving the APA challenge to the 2022 interior cancellation of a 2019 lease renewal. And the court below held that it lacked jurisdiction because it construed the complaint as being the source of the right, being the 1966 lease. And it said the complaint was challenging the government's interpretation of that lease. That obviously is manifestly wrong because the government's cancellation was not based on the lease, much less any interpretation. The government's cancellation was based exclusively on statutory and regulatory grounds. The complaint challenges those grounds, and judicial review of statutory and regulatory views obviously falls within the heartland of APA jurisdiction.
What's the source of, on your view, what's the source of the alleged right to renew the leases?
So
If not the leases, it's the APA.
It's the APA. Remember, if the cancellation said the government cancels a lease and said, we cancel this lease because we think it violated NEPA, you'd have a classic APA review of the government's view under NEPA. Well, guess what? That was one of the reasons the government canceled this lease.
I mean, that's a very odd view that review would be separated. If you're claiming under the leases, you go to the Court of Federal Claims. But if you're saying that the explanation for construing the leases was not adequately articulated and therefore arbitrary and capricious, sounds like APA, so you come here.
No.
And that's an odd.
Well, that may be, but that's not this case. No one is saying that they arbitrarily construed the lease. They arbitrarily and unlawfully construed a statute and a regulation. The cancellation is based, recall, on the Downs opinion, and the Downs opinion cites Regulation 3514 and advises BLM that they are authorized to cancel a release. Remember, there's already a release here. And the Downs opinion says there are 3 regulatory and statutory reasons you are authorized to cancel the release, and the cancellation relies on that. The first is it construed, i.e. the agency construed Section 508 a statute to require Forest Service consent. Second, the Downs opinion says there's a series of 4 regulations that require the government to use the standardized renewal forms that only give you a preferential right of review. And third, the Downs memo says the renewal violated NEPA because you did not consider a no action alternative. Now, it also retracts the Giorgiani opinion, which comes from the Trump administration. And the Giorgiani opinion gives you competing views of the statute and regulation. So who is right between Giorgiani and Downs is a classic APA. The government doesn't dispute if the Downs opinion is wrong based on statute and regulation. There's an adequate release adequate renewal, a lease that is in existence. So it's not like we said and brought a complaint saying, Interior, you must renew a lease. It's already been renewed. What we have is a cancellation. And I think the example we give in our brief, if an agency says, we're going to cancel a lease because you have a left arm, or because you're left-handed, or because it's a Tuesday, or because we construe a statute that says the lease was unlawfully renewed, that is a paradigmatic classic APA challenge. This court, and we cite the Megapulse, which is cited then on Crowley, that even if the court below, the district court has to construe the lease, this court said pretty lucidly that that does not transform what is otherwise within the jurisdiction of the court into an action on the contract. What matters is the source. So if the government had said, we construe this lease, you violated it, then that's a disguised breach of contract claim. But that's just not this complaint. The complaint is, and I think it's in paragraph 113, seeks classic APA remedies. It seeks vacature of the Downs opinion, vacature of the cancellation, and a declaratory relief that those actions were unlawful. And the district court on remand has to sort through the regulations and the statute. And the government doesn't dispute that if once those are vacated, the lease already got renewed in 2019. It's only 3 years later when the government canceled it.
They're only impermissible if a court would agree that the interpretation was inconsistent with the leases. the rights here clearly emanate from the leases. You don't have the leases, there's no discussion. That's what the fight is all about.
So there's no discussion. I mean, there's no dispute that Article 3 standing and this case wouldn't be here but for a contract. But every single decision of your court and Megapulse is saying the fact that there's a but-for relationship between the cause of action and the fact that you're in existence does not deprive the court of jurisdiction, or this court could never review arbitrary and capricious deprivations of contractual rights based on statutes, regulations. I mean, this is a classic APA case. We cite the Texas oil case where the court said we unwind unlawful agency action, and that meant the underlying contract was valid. So I just think that the but-for was a bridge you crossed in Megapulse. If you remember, in that case, it was a government contract. And the issue in Megapulse was the government was trying to release trade secrets, and the plaintiff there said, you can't take our trade secret information. And the government said, no, we think we're entitled to do that under the contract. That case turned on a contractual interpretation of the contract vis-a-vis the Trade Secret Act. So it cannot be the fact that we're here because we have a renewed lease. The government canceled it, not even citing any interpretation, not citing the lease at all. It said you violated our statutes and regulations.
If we agree with you, that would require us to send back counts 1 and 4.
Correct.
Wouldn't affect counts 2 and 3.
That's correct. Absolutely correct. That's why, the jurisdictional issue, I think, is quite straightforward, because you can't change the fact that the only basis for the cancellation did not cite the lease, did not construe the lease, did not interpret the lease, and we're not challenging any governmental interpretation of a contract. Plain and simple. The preference right lead application is a much more, I can turn to it, but it is a much more complicated, regulatory analysis. Before I turn to the preference right leads applications, the one thing I will say, because the other thing the court below relied on was specific performance. And specific performance, we think, would have to be where we're asking a court to order the government to take specific action on a contractual provision. Of course, we're not doing this here. We're just asking to unwind unlawful agency action, return to the status quo ante, which is an existing lease renewal that, the Trump administration entered into back in 2019.
I don't understand what regulation you think they violated, or what statute.
So we don't think that. What I'm trying to say is.
No, I don't, what I'm implicit or explicitly trying to say, I don't think the way you're looking at it rings true as I read the record. They were acting within the authority that they are given based on their view of the contract.
No, they were.
It's a paradigmatic example of a contractual dispute. There's no rights here save for the contract. There's nothing in the regulations that answer the questions that are at issue here.
Yes.
Parties are fighting about.
With all due respect, 3514 is a regulation. The interior cancellation, which is in the joint appendix, says we're relying on the Downs opinion, and I'll just go through it. Downs said that you have to have forest consent. Giorgiani says, I read the statute not to require Forest Service consent, and the Forest Service had no authority to veto this. The second point is Downs says, Giorgiani relied on a regulation, 3221.4F. You may disagree with Giorgiani's review of the regulation, but he construed that regulation to give Twin Metals a right to automatic renewal. Giorgiani and we also relied on the contract. Downs in turn says, I've got 4 regulations that we think don't stand for that proposition, that when read in combination with 3221.4, don't give Twin Metals an automatic right. So you may be right. We think you will be wrong, but it'll be on appeal. But the district court has to actually going to have to look at these regulations and decide between Giorgiani and Downs who is correct. And then the third provision has nothing to do with the lease at all. The entire authority for saying you can terminate or cancel the lease is because the Department of Interior did not conduct the right NEPA analysis. So again, I started out by saying if we had a lease and Interior says you got to cancel it because you violated NEPA, I don't see how the government could say with a straight face that that's not within an APA jurisdiction, and that's one of the bases for it. Now, it's true that there is a dispute about the interpretation of the lease, But the government did not rely on anything to do with the lease to do it. So the exclusive basis is all statutory and regulatory
They'll
views.
say that they surely did rely on the lease in the sense that what they were saying was that we have the authority. There is nothing in the lease that prohibits us from this acting one way or the other. You
Well,
have lease rights. You're claiming your lease rights have been violated. I just leaps out. It's so clear.
but that,
I don't.
we don't have a lease, right? We had a lease. So there's no question it was a
You're claiming
contract.
that under the lease, the government could not take these actions under the lease.
But that's not the complaint. The complaint says under the authority that they cited under the regulation and statute, they incorrectly.
I think the government, I'll let them speak for themselves. The way I construed it was that the government is essentially saying, we have the authority under law to be able to approve or not approve here. In a situation where there's a lease, especially when there's nothing in the lease that gives you the rights that you're claiming.
Assume you're right, then your view is the Trump administration erroneously gave us a contract. They gave us a lease. You may be right that the Trump administration was out to lunch, but they issued a lease. The Biden administration came in and said, we can only get out of our contractual relationship if we have the regulatory authority to do it under 3514. And we're going to cite a bunch of statutes and regs that do that. You cannot read the Downs opinion is 10 pages of statutory and regulatory analysis that doesn't analyze the lease. It doesn't say you didn't have a right under the lease. It doesn't say you didn't have a right to renewal. It literally says when the Trump administration signed that lease, it violated our regulations and our statute. The government can see, I don't think they would dispute if Ms. Downs is incorrect, the cancellation is invalid and we have a lease. That's an APA claim. Now, again, we could have brought you breached the lease argument in the Court of Federal Claims. Well, we didn't bring that claim. That claim, to be sure, belongs in the Court of Federal Claims. And we think we do have a contractual claim because, they breached the lease. But we have also an APA claim that the regulatory and statutory analysis and their justification, again, if the Downs opinion says you should cancel this lease because we don't like the way Twin Metals, we don't like the foreign country they're from. That doesn't belong in the Court of Federal Claims. It may be a breach of contract, but you can still challenge it in district court.
I guess another way of putting it is that Court of Federal Claims doesn't adjudicate whether the administration or any administration properly construed a statute or regulation.
Yeah, they would. Yeah, in a breach of contract, I probably think they would have jurisdiction to view a government's defense under a statute, but we could not bring this claim in the Court of Federal Claims. They simply would have no jurisdiction.
Regulation, one of the regulations you're relying on says that the terms of the lease renewal will be governed by the terms of the lease.
Yes, I know. And that's when the Downs opinion says, I've got 4 other regulations that give light to that, and we disagree. All we're saying is that the court has jurisdiction to construe the regulations. What you're exactly saying is something that the district court is free to say, and we're free to appeal. But that's right. That's reading a regulation. And the fact, again, that the court in Megapulse and in Crowley said, if the fact that the contract has to be construed in the course of this, that doesn't deprive the court of jurisdiction. It doesn't even affect the NEPA analysis and the Forest Service consent. You can you can burn the lease and you still have to resolve the Forest Service consent issue and the NEPA claim. The lease is just, there's no construction of the lease. There's no citation to the lease. The lease is irrelevant. We're literally talking about a NEPA. Did you have to go look at a no action alternative? That's a pure question of law, has 0 to do with the lease. And does the Forest Service has to consent? The court can say nothing about the lease in response to those claims.
Government contract law is very complicated. I mean, there's a federal acquisition regulation that reads like an encyclopedia. And it's just not right to say that the CFC deciding a contract claim won't routinely have to construe all of the positive law reflected in that regulation.
I agree.
and reflected in the statutes that give the government authority to contract in the first place.
Totally agree.
So this kind of, you know, separate the attempt to separate the terms of the lease from the terms of the statutes and regs that sort of define the government's contracting authority here just seems like that's a hard thing to untangle.
Well, two responses. First, you can always bring a case in this court that also where the CFC has concurrent jurisdiction. It's just depending on the nature of the right sought, the nature of the relief. But second, and more importantly.
Yes, but your theory is that we have to sort of cleave the statutory and regulatory questions from the contract questions.
No, the theory is where the source of our right is exclusively on the APA because we are challenging the government's exclusive statutory and regulatory rights. If you just, again, looking at the NEPA and the Forest Service consent issue, that we couldn't bring that case in the Court of Federal Claims. It has nothing to do with the FAR. It has nothing to do with the lease. We have a lease that the Trump administration renewed in 2019. And when the Biden administration said, Interior, you can cancel this because it violated NEPA, you don't look at the lease to resolve that. Doesn't matter what the lease says. It matters what NEPA says. When it says you should have gotten Forest Service consent, there's nothing in the lease that speaks to this. You couldn't bring that case. The only issue where, as an incidental matter, the lease will get construed as this battle between Giorgiani and Downs about what kind of standardized form has to be used and what that means. We think we independently have an argument that the lease controls the regulation. But that is jurisdictionally irrelevant that the district court or even this court would have to construe a contract in an APA claim. Otherwise, you're depriving this court of jurisdiction to review any unlawful agency action that relates to a contract.
Suppose there were no cancellation. You say, you think the lease was validly renewed. The government thinks it wasn't validly renewed. So they refuse to perform. You bring the breach of contract claim and then you litigate whatever.
Well, that would be a breach of contract claim if there was no cancellation.
Right. But
I think that's
turning on the statutes and regs that.
Well, I guess if they said we're breaching the contract, I don't know.
I don't know. I mean, it
I've never seen that.
Validly renewed because the Forest Service didn't consent or whatever.
The reason why I'm struggling with the question is Interior has this regulation that tells you when you can cancel a release and you can't, cancel a renewal, and you can't cancel renewal because you think there was non-performance. You can only cancel it because, well, you can, but they said you also can cancel it if it violated the statute and regulations when you entered into it. And that's what makes this the classic APA challenge. If there was no 3514 and there was no Downs opinion, then it's going to turn on what the complaint looks like. But if it's a disguised contract claim, I think under the two cases the government cites, where it's just the government breaches the contract. But this is not a breach of the renewal. I mean, well, it is.
What's the violation of 3514? It's not in your opening brief. In the reply brief, you argued something for the first time in the reply brief.
We're not arguing 3514. That's the sole basis of the cancellation. So
Then what's the violation of a regulation? Since you don't want to focus on the lease, and I'm struggling with that.
Because Downs says.
Say, look to the lease. You're arguing the reason we have a claim that's viable is because they allegedly violated a regulation. Suppose we go to the merits of that. What did they violate?
What did the Trump administration, the Biden administration?
Whatever claim you're bringing, where was the violation of a statutory provision or regulation?
We're not saying, if I could just be clear on this, we're not saying the Biden administration violated a statute on this claim. We're saying the Biden administration erroneously accused and found that the Trump administration violated the statute and regulation.
That really doesn't work.
That's the Downs opinion.
No, you're saying, you're bringing a claim to the court and saying, we were acted against and our rights were violated. And so, of course, as a judge, I'm saying, based on what? Now, your whole argument today has nothing to do with the lease. It has to do with the regulations they were relying on. So now I'm curious to know, what regulation did they violate?
So
You can't then say, well, Trump did this and Biden did that. You have to now answer the court and say, what specifically was the
So an
regulation or statute that, because your brief is not clear on this.
well,
I'm looking at it again. It is not
I
clear.
think our brief does say, under the APA, you're allowed to bring judicial review of an agency's
Oh, no,
construction of a
counsel, please.
statute.
All I want to know is, just so I can think about this carefully, beyond what I've already done, what regulation or statutory provision do you think the government actors violated in acting against your client?
Only one, as part of our attack on the Downs statutory and regulatory analysis, we say that Downs relied on 4 regulations that we think are inconsistent with the 3221.4F, which you just read earlier. You know, that you have this right to renewal consistent with the terms of the lease. So we think, in terms of that battle of the regulations, we think the Downs opinion incorrectly reads the regulations in violation of another regulation. That's a pure
And
APA
so
challenge.
the right your clients had that was abrogated is what?
A regulatory right to automatic renewal of the lease.
Automatic renewal. You're saying I want to make sure I have this clear. Your argument to this court, because this, for me, given the way you're arguing, is the heart of it. There was a regulatory provision that gave us a right of automatic renewal.
That's
And
what
I
you're-
want to say, I sure didn't come away from your brief understanding where that was coming from. I'll look again, but I want to make sure I understand where that's your argument now.
Yeah, but with
I
all
don't
due
see it.
with all due respect, that is what Giorgiani, the Trump administration Interior Secretary, said.
No.
And Downs rescinds it.
No, you're at a different stage now.
I agree.
Okay, I know you do. I certainly know you know. But the point is, I don't know what it is you're resting your argument on, because I don't see the regulation that gives the right that you're asserting.
So if the government said, just you, Interior, we want you to cancel this lease because of NEPA, we're not going to come into court and say we have a right under NEPA to the release. I can't say that. What I would say is we already have a renewal. The government is erroneously relying on NEPA. Their construction of NEPA is unlawful.
Why don't you give us a site
Right.
and some text? Statute, don't say APA, but a statute or a reg that gives you this right. Where, just give me the
it's-
site and the text.
It's the APA. It's the arbitrary and unlawful,
No, I don't.
Just assume I don't buy
but
it.
our cause of action is under the APA.
Cause of action is, but the source of the substantive right to renewal.
There's a
In the
contractual.
binding law or the reg.
So I guess a contract is positive law. The actual
Yeah, the-
underlying right is under the contract.
Okay.
It's a renewal, it's a contract. And the cancellation,
QED.
Yeah,
Well,
we're
then-
coming right back to the same place.
well, then anytime you have an unlawful agency construction of a statute, that's the basis for action taken on a contract, you would be depriving this court of jurisdiction.
Before you move on, just one question about the remedy.
Yeah.
It's not quite specific performance, but it's not too far off. It's setting aside an action, the effect of which is to reinstate the contract. You've also asked for a declaratory judgment. I mean, suppose you and I have a contract and I say it's been repudiated and I'm not going to perform. You go to district court for a declaration that the contract is still in effect.
Yeah, I think
Classic contract remedy, and it seems a lot like what you're doing here.
the difference is that forget the repudiation, you have the unlawful agency action of a separate final agency action, the Interior cancellation, and the Downs opinion. If you set those aside, just the status quo ante, the APA, it's just like the Texas oil case, the renewal is just there. The court doesn't have to do anything. If the court just sets aside the unlawful agency action, no other relief needs to be done. It's just the release is by force of law, it's in existence. So the court doesn't have to order Interior to do anything. It doesn't even have to declare the lease valid. If you set aside the cancellation, the release is there. So you could have a complaint that just says, please set aside the Downs opinion, please set aside the statutory analysis in it, and we win, we go home, we're happy. And that's an APA, that's not specific performance, that's just set aside unlawful agency action.
Okay.
So if I can turn, I guess, to the next issue, and that is the preference rights lease application. So another regulation here, I mean, the two are somewhat parallel in that the cancellation is based on one regulation, denial of the preference right lease applications is on another regulation. And we think those are parallel, subject to APA challenges. One is a cancellation and here is a declination of an application. So the government relies on 2310-2, and that says that it's mandatory that you deny any application if the land is subject to a withdrawal, Forest Service withdrawal request, and the consideration of that application is discretionary. And so what the BLM decision says is the decision here was discretionary, therefore it's denied. And there was no other analysis. And we think that that just is completely contrary to the regulations, that BLM did not have the discretion to deny the preference right lease application. And I can walk you through that, but we rely first on the 350110, which says preference right leases are issued to holders of prospecting permits that discover a valuable mineral deposit. And then importantly, 3507-11 and 19 then carefully delineate exactly when BLM will grant one of these applications, and then it says, and here's where we're going to deny it. And then most importantly, they expressly point out to the holders of these prospecting permits when they have complete discretion. So in 3507-11D, the BLM informs the public that if you're a prospecting permit and you have land that relates to the reorganization plan number 3 lands, which are acquired lands, you just are not entitled to a preference right lease. And then the regulation 3505-50, BLM says our decision to grant or deny this application is within our complete discretion. We also think that the regulatory history, sorry,
I don't have all the numbers in front of me, but suppose I thought that BLM's discretion is circumscribed, but the Forest Service has discretion to refuse consent, which then compels denial. What result then?
Right. And so the government says exactly what you said. Forget even our discretion. The fact that the Forest Service discretion would trigger the the mandatory denial under 2310. And we have several responses. The first, most obviously, is the Calcutt-Chenery response, that was not the decision on which the agency relied. So you would have to remand it because
No, but if what I said, if what my question suggests is right, then it's just illegal. You just lose on legal grounds. There's nothing to remand. The decision, the allowance of which is discretionary, and then end of case.
Yeah, but that's not what the agency said. That's what they now want to say in their brief. It's a new argument. It's just under Chenery, they would have to say, they said it's not within BLM's discretion. The government in their brief says.
No, I get that. I get that, but we don't do Chenery remands when a claim is just legally invalid.
Well,
regardless.
I mean, maybe.
We do it for exercises of discretion.
Maybe yes, maybe no. I'm not so sure about that. But even if you're correct on that, we think it is a very litigable issue, and we would litigate it, that the Forest Service doesn't have that kind of discretion, that absolute discretion. And we've got several arguments. First is just the statute. We would argue under the statute that the Forest Service is circumscribed by, it has to be limited to development and utilization. More importantly, we think that, remember in 2016, the Forest Service attempted to deny consent, and they issued, I think it was a 20-page document purporting to have reasoned analysis. And that would be just subject to an APA challenge. Finally, we would argue that, and we think there's a good argument, that the Forest Service already consented here. And that would happen at the prospecting permit stage. And we would get into a fight. There would be a lot of litigation over this, but the actual Forest Service consent to the prospecting permit says, we're not consenting to your preference right lease applications under reorganization plan number 3 lands. And the manual distinguishes between those reorganization plan number 3 lands and the 508 lands. And so, and it says the consent is provided at the prospecting stage. So we would be arguing like all of this stuff that hasn't been briefed, which is why I said this is a very complicated issue. But all we had below was the agency saying that the Bureau of Land Management didn't consent. Now they come back and say, well, the Forest Service had discretion, but we would say, what are you talking about? We have a lot of arguments under the Forest Service, the Forest Service's ability or lack of ability, but you know, a lot. If
So I
they,
guess so what I hear you saying is even spotting me, no Chenery.
oh, we have lots of arguments.
Remand for those legal questions.
Yeah, and my guess is that the district court wouldn't even sort that out. We would go back first to the Forest Service. And remember, we had, if you look at what, again, this is what the Trump administration was doing. The Trump administration was saying Forest Service didn't have a right to veto the lease renewals. So we're not sure what the government thinks of the new government will think of our Forest Service arguments. But we have a series of arguments that we would make that the Forest Service just can't say we're not in the mood. We think the Forest Service can impose reasonable conditions. We think there has to be a NEPA analysis. We think there has to be gazillion permits we'd have to get before we mine. But this is just a preference right lease application, which just means we have a right to get in there as opposed to anyone else. It's not a right to mine. Of course, we have a long, long way to go, but I just don't think the government can say, and I think this is, again, another regulatory issue. I think the government is saying under 2310, the thing that triggers the mandatory denial, that's something that has to be within the agency's complete discretion. And the fact that the regulations so clearly demarcate between when the agency has discretion and just these other ones, and this is what I was going to get into about the regulatory history, although I know you kind of were getting into the Forest Service. And this is why, again, telling you you're better off waiting, but it's a very complicated history where, and it's in the 1999 preamble to the regulations, the government talks about there's been a history of saying you're entitled to these preference right lease applications. But as a historical matter, we've always treated reorganization plan 3 very differently. And we now want to make our regulations clear that you're not entitled to it. And then the rest of it, we're just converting into plain English. And so the previous one said you are entitled to these preference right lease applications. But I will spot you. This is, you want to wade into this. It's a lot. And Monday we have a new administration. The president has.
All right, we have your argument.
Thank you.
Ms. Jaffe?
May it please the court, Rebecca Jaffe appearing on behalf of the United States. I'm going to jump right into the contract claim. The source of plaintiffs' asserted rights is the lease contracts, not any laws. In making this determination, the court looks at the substance of the claim, not any artful characterizations. Interior canceled the leases because in Interior's view, renewal was discretionary. That's at JA 251. And Interior said, when we renewed the leases in 2019, we did not obtain the Forest Service's consent to renewal, and we did not consider a no renewal alternative under the National Environmental Policy Act. Interior said that was wrong because renewal was discretionary, and therefore we had to consider not renewing and had to obtain Forest Service consent. Twin Metals says Interior erred because it was entitled to non-discretionary renewal under the contract terms. In the complaint, plaintiffs say, considering a no renewal, no action alternative was not an option under the 2004 leases, which granted Twin Metals a right to renewal that was not conditioned on environmental review. That's at JA 58. They say the third renewal was not conditioned on Forest Service consent. That's at JA 53. They say the appropriate interpretation of the leases is granting non-discretionary renewal. That's at JA 41. Plaintiffs' counsel.
Don't they argue as a matter of law, Forest Service consent is not required? Isn't that the crux of their argument? And if they're right about that argument, then isn't that an APA claim?
Your Honor,
Or just resolving that argument, isn't that a classic APA claim?
the crux of their argument is Forest Service consent wasn't required because renewal was non-discretionary. And there's no statute that gives them a right to non-discretionary renewal. Under the Megapulse test, this court has to look at what's the source of the right, and is it a truly independent source, truly independent from the contracts? So in Megapulse, they said, the Trade Secrets Act, that's the independent source of our rights. We developed this data before we ever contracted with the government. We have these rights. Here, there's no statute that says you have a right to non-discretionary renewal. The statute that says you have to have Forest Service consent and the statutes that authorize leasing, they don't actually mention renewal at all. Plaintiffs point to the regulation from 1966 that addressed renewal. That's 43 CFR 3221.4F. That says the lessee will be granted a right of renewal under such reasonable terms and conditions as the Secretary of the Interior may prescribe. So one, the regulation doesn't say whether renewal is discretionary or non-discretionary. And two, you have to, the regulation encompasses the terms, and you have to look at the terms to figure out whether it's discretionary or not. The council, Twin Metals Council talked about the Downs opinion, but they're not saying in their complaint, Downs misconstrued NEPA. This is actually how NEPA works. They're not saying in their complaint, Downs misconstrued 16 USC 508B, and this is how leasing in this area works. They're saying in their complaint, we had a right to non-discretionary renewal. That's the source of their right. Plaintiffs also point to the regulation that says, that authorizes Interior to cancel a lease. That's 43 CFR 3514.30B. That regulation says nothing whatsoever about renewal, much less non-discretionary renewal. It says, BLM may cancel your lease administratively if we issued it in violation of any law or regulation. So
Isn't the relief that they're requesting vacature of the Downs opinion?
the relief that they're requesting is specific performance. They're asking the court to set aside the cancellation of the contracts and declare that the contracts are valid and in force. That is specific performance. Congress, when it promulgated Section 702 of the APA, specifically said in the legislative history, we don't want the APA to be a mechanism for people to get specific performance of government contracts. And there's policy reasons for that, but that's what they're seeking here, is specific performance.
Does it matter that the renewal and the cancellation are separate agency actions?
The renewal in 2019 and the cancellation in 2022?
Yeah.
I'm not sure that I see how it would matter for the claims before this court now. The agency action before
I'm
this.
not sure it does. I'm not sure it does either, but look, you know, you have authority for saying you look to the ultimate source of the right. I get that. It seems to trace back to the lease. But I mean, another way of thinking about this is you can disentangle if the cancellation rests on the legal proposition that Forest Service consent was required. It's a statutory question. It's unconnected to the prior renewal. It feels a little more APA-like. It's discrete. And answering that question, you don't need to know whether ultimately they're entitled to renewal of the lease. Could still be the case that renewal is totally discretionary and they've just given a legally bad reason for exercising their discretion.
That's not the complaint that plaintiffs brought, Your Honor. The complaint that plaintiffs brought says the third renewal was not conditioned on Forest Service consent, that the 2004 leases granted Twin Metals a right to renewal that was not conditioned on environmental review, that the leases should be interpreted as granting non-discretionary renewal. That's the complaint that they chose to bring. I wanted to point to the court to the specific citations about the fact that what they're seeking is specific performance. They request a declaration saying that the 2019 leases remain valid and in force. That's JA 24 and JA 63. They ask the court to set aside the cancellation. That's JA 62. And that's specific performance, a classic contractual remedy.
I guess I'm having trouble understanding how asking for the court to declare that, like the Downs opinion, I'm looking at their prayer for relief, which is page 44 of the complaint. I don't know what page of the JA it is because what I'm looking at, it's not paginated. But it asks that for the court to declare that several actions are contrary to law and be vacated and set aside. And there's a laundry list of them. A through E at paragraph 133. And then, paragraph 134 is declared that the leases remain valid, et cetera, et cetera. I don't understand how any of that is requesting specific performance. It's seeking a declaration that certain actions or opinions were erroneous, and then to the extent that those were relied upon for the government to take other actions to not renew the leases, then that legal effect flows from that. But how is any of that specific performance?
So I have two responses to that, Your Honor. The first is that the actions listed in paragraph 133 of the complaint, which is JA 62, we're not saying that all of those are contract claims. For example, they list their challenge to the rejection of their preference right lease applications, and we're not suggesting that that's a contract claim. So we're only pointing to the pieces that challenge the lease cancellation specifically. And then my second response, and the more important one, Your Honor, is that under Megapulse, the court looks at what's the essence of this claim. At its heart, what is it? Is it a contract claim or is it an APA claim? And at its heart, this is a contract claim. And to make that determination, the court looks at the source of the right and the relief that they're seeking. And on these specific facts, the constellation of facts here, what they're seeking is specific performance. The source of the right is the contracts. They're not able to point, and counsel pretty much conceded that before, that the source is the contract. There's no statute.
So claim one, which is at page 39 of the complaint, I don't have the JA's page, says that the lease cancellation violated the APA because the reconsideration of the Georgiani opinion was untimely, et cetera. And the Downs opinion was erroneous, essentially. How is that a contract?
Because, Your Honor, they say in claim one, paragraph 113, a no renewal, no action alternative was not an option under the 2004 leases, which granted to Twin Metals a right to renewal that was not conditioned on environmental review, according to the Georgiani's opinions, correct and reasonable interpretation. So, and then in paragraph 114, they say they have a right to successive renewals of the leases. So, the essence here is a contract claim. And under
Well, I guess what I'm may make it a little bit more plain. So yes, it does allege that, But if it doesn't allege that, then how do we know whether there's an injury and whether there's standing? But the claim, that claim in essence seems to be all about the opinion. And we hear those APA cases, you know, every day of the week, whether some interpretation, whether it's a interpretive ruling or a more binding regulatory ruling, whether those are erroneous or not. I mean, that's within the heartland of the APA. I mean, sometimes we have to figure out whether it's final agency action and it's actionable, but I mean, that's what the APA is for, right?
Your Honor, I have a couple responses to that. First, we certainly aren't challenging plaintiff's standing, but we don't think that paragraphs 113 and 114 are there to establish standing. You could say, you know, we have standing because we have interest in this area, we've invested in this area, and we're bringing a claim based on something else.
I mean, I guess all I'm saying is that if all they said in their complaint was, we think that the Downs opinion was erroneous, everyone's response would be, well, who cares? You got to have it some sort of context. And the reason we care is because it led to the cancellation of leases. That doesn't mean that the lease is the basis of the claim.
I mean, isn't your point, what's the basis? It's the point I was asking opposing counsel. So what is the alleged regulatory violation? The APA, this can't be an arbitrary and capricious claim the way the case is framed. That would be silly. So if we're looking at the APA, we're looking at an alleged violation of law. And so the question becomes, well, what? What regulation, what statute are they claiming is violated? And I think if I'm understanding you correctly, you're saying no matter what else they say, bottom line, they're saying under the lease, this could not happen. That's where our right comes from. Is that right?
Yes, Your Honor. Yes. And exactly. And back to Judge Wilkins' question, let's just say, hypothetically speaking, that Interior had done a NEPA analysis on whether to renew or not, and said, we're not going to renew based on the NEPA analysis that we've done and the environmental consequences. And they brought a claim and said, you didn't do NEPA right. You didn't consider X, you didn't consider Y. That would be an APA claim. And we would still be in a place where the cancellation is to the court's point, why we care, why we're here. But the claim they brought is you couldn't do NEPA because we had a right to non-discretionary renewal. That is a contract claim.
Can I point to any regulation that says they had a right to non-discretionary?
Yes, Your Honor. That was a more concise way of saying that. If the court has no further questions on the contract claim, I will turn to the preference right lease application claim. So turning to the preference right lease application claim, plaintiffs' challenge to BLM's denial of their preference right lease applications fails as a matter of law. Plaintiffs' lease applications were pending when the Forest Service filed an application to withdraw relevant lands from mineral leasing. Under the Federal Land Policy Management Act, when Interior receives an application to withdraw lands, then the lands must be segregated from mineral leasing. That's 43 USC 1714B. Upon publication of a Federal Register notice announcing the application, the land shall be segregated. And BLM regulations mandate that BLM must reject discretionary applications to use segregated lands. 43 CFR 2310.2D. That regulation says applications for the use of lands involved in a withdrawal application the allowance of which is discretionary, shall be denied. At the time of the withdrawal application and the segregation of the relevant lands, plaintiff's lease applications remain pending and issuance of any leases remain discretionary. Because it was discretionary, BLM had to deny the applications. That's a straightforward application of the regulation's plain language. There are two steps where the United States had discretion. The court doesn't need to reach any of those steps because the material question is whether there was any discretion, and that alone suffices to require denial. But in any event, the two steps are: one, BLM must determine that issuing a lease is in the best interest of the United States under 16 USC 508B. And two, the Forest Service must consent to the issuance of a lease. Those are two discretionary steps. And Interior had not yet decided that issuing a lease was in the interest of the United States. And the Forest Service certainly had not consented to the issuance of leases, and nobody disputes that they have the right to consent. So the applications were discretionary. Twin Metals relies heavily on an interpretation of the regulations that the plain language of the regulations doesn't support. The regulations don't say, if, these are the only reasons by which your lease application may be denied. And they don't say, if you do these three things, you must be entitled to a lease. I think it's important to take a step back here and recognize that these regulations apply to a variety of different leasing statutes. For example, under the Mineral Leasing Statute, under the Mineral Leasing Act, a prospecting permit holder who discovers a valuable mineral deposit is entitled to a lease. That's what the statute says. But 16 USC 508B is an obscure specific statute that, to the best of Interior's knowledge, has only ever applied to 4 leases ever. It only applies on some national forest lands. And that statute says that the Forest Service has discretion whether to consent, and it says that the Interior needs to decide that issuing a lease is in the best interest of the United States. Plaintiffs make an expressio unius argument, but that doctrine only applies when the circumstances support a sensible inference that the term left out must have been meant to be excluded. And this court said that in Delaware Riverkeeper Network 857 F3D 388. The point here is that the statute gives the Forest Service discretion. The statute says the Forest Service can consent or not. The Forest Service has discretion. Interior has discretion whether or not to determine that a lease is in the best interest of the United States. Plaintiffs argue that this is a post hoc explanation because in the decision that Interior made, rejecting the preference right lease applications, Interior referred to BLM's discretion instead of the United States' discretion. That's at J234. We think that's harmless error for a couple reasons. First of all, and most importantly, BLM cited the applicable regulation, 43 CFR 2310.2D. This isn't a situation where Interior cited regulation X, and now post hoc counsel is citing a completely different statute or regulation. This is a situation where they cited the regulation and they said, this is at our discretion. We believe BLM has discretion. Plaintiffs disagree. There's no question the Forest Service has discretion, and the Interior's path can reasonably be discerned. If the court has no further questions on the preference right lease application claim.
What about the Forest Service discretion?
That to consent or not to consent?
Consent or not consent, yeah. Is that sufficient?
To deny the lease applications? Yes, it's the existence of that discretion. Because the application was discretionary, it had to be denied by law. Plaintiffs argue that they're entitled to get a decision from the Forest Service, but they don't have any such right. The The application was discretionary at the time that the lands were segregated from mineral leasing. And it's the existence of that discretion that mandates denial of their applications.
And either, in your view, either discretion vested in BLM or discretion vested in the Forest Service is sufficient.
Yes, Your Honor. We think both exist, but even if you disagree with us on
We only
one.
need to resolve one of the two.
Yes, Your
To
Honor.
rule in your favor.
Yes, Your Honor. If the court has no further questions, it should affirm. Thank you.
Good morning. It may please the court, Aileen McGrath for the intervener appellees. I agree with the government that as to the jurisdictional question, the complaint speaks for itself and makes clear that the source of the rights that Twin Metals is asserting in this case, and I believe I heard Twin Metals to articulate it the same way, despite cloaked under the APA, the source of the rights that the plaintiff asserts emanate from the contract itself, and that alone is enough to resolve the jurisdictional question. I think what I will add is that to the extent that Twin Metals has raised any counter arguments, I think that the court's existing precedent answers those counter arguments and many of the questions that the court has asked here today. Maybe I'll start with the questions that Judge Wilkins was asking a moment ago about the relevance of the need for the court to construe any federal regulations governing the determinations made in the Downs opinion in reference to paragraph 113 of the complaint. This court's decision in Spectrum Leasing at footnote 5 expressly said that the need to consider federal regulations and construe those federal regulations does not transform what is otherwise a contract claim into something else. That's exactly the scenario here. And that's even putting aside the fact that, as I think the government has already pointed out, with respect to each and every one of those challenges to the Downs opinion, the government's argument, Twin Metals' argument, is that the government disregarded rights that belong to Twin Metals by virtue of the leases, not that the government otherwise misconstrued or misapplied rights that Twin Metals has under any other source of federal law. And so Spectrum Leasing, I think, disposes of the question whether the relevance of those federal regulations changes the essential character of this claim. Number two, Twin Metals argues that the fact that the government invoked a provision that allows it to cancel contracts in certain circumstances, and the fact that the contract itself contains a reference to a federal regulation, that too changes the essential nature of the contract. Here too, the court's precedents already answer that question. On pages 78 to 79 of the court's decision in Ingersoll Ranch, the court considered an identical argument about a contract that likewise referenced a federal regulatory provision and a government cancellation that likewise invoked a similar source of authority for the government to cancel a contract. There too, this court said that's not enough to change what is at its essence a contract action. Number three, the court here, I've heard Twin Metals to say that allowing jurisdiction to vest in the Court of Federal Claims here would shunt all sorts of other challenges to an agency's reasoning and decision-making to the Court of Federal Claims. That is another argument that this court rejected in Ingersoll Rand as well, where the plaintiff made exactly that argument. And so again, as I started with, even though you can look plainly at the face of the complaint and to the arguments that have been made here to see that this case belongs in the Court of Federal Claims, you can also look squarely to this court's existing precedent. Beyond that, I'll very quickly, if I may, say something about the Forest Service consent issue as to the preference right lease applications. And as to that issue, we agree with the government, and this is why we haven't taken a position on the 28J letters and all the documents that have been exchanged back and forth, because our view is that none of that matters whatsoever. The regulation that the court needs to construe here, as this court has already explored, speaks to whether the allowance of an application is discretionary. The plain language.
What about Ms. Blatt's prudential arguments? This is messy. It hasn't been a focus of the briefing.
The reason it
We're
hasn't
not a
been.
court of first view or review.
Because I don't think the court needs to, and in fact could not, in properly construing that regulation, consider questions about what the Forest Service might have or would or has done. Because the regulation looks only to the existence of whether the Forest Service has discretion, the Forest Service's position, and any arguments that Twin Metals might make in response to that position is all entirely beside the point. The 43 CFR 2310.2 directed Interior through the Bureau of Land Management to deny these applications based on the existence of that discretion and not to require the Forest Service to act upon it. So anything that the Twin Metals or anyone has tried to introduce in the record that speaks to that possibility or arguments that might be made is completely beside the point as to this interpretation, this interpretive question.
And you'd be pressing that argument even if the Forest Service had consented on the last round?
The argument would be the same, yes, Judge Katsas, because the question is whether there's the existence of discretion at some level of the government. And to be clear, we agree with the government, as I think we clarify in our brief, that BLM's discretion here also resolves the issue, but you need look no further than the existence of the Forest Service's discretion. Whether it actually took a position doesn't matter for purposes of answering that question.
Yeah, I understand why you read it that way. It's a much less attractive position if they have in fact consented, but I understand.
Thank you. Unless the court has any further questions on either of these issues, I think we would ask the court to affirm.
Thank you. All right, Ms. Blatt, I believe you are out of time, but we'll give you 3 minutes on rebuttal.
Some very quick points on the jurisdiction issue. They keep framing this as, quote, we're alleging a non-discretionary right to renew. That's not in the complaint. The paragraph that they cite and the paragraph the district court cites, which is 114, uses the right to renewal, and then we cite a regulation. We don't cite the lease, we cite 3221. So the only non-discretionary right to renewal that's mentioned in the complaint refers to a regulation. What we're seeking is a right not to have our release arbitrarily canceled. JA 260 is the cancellation. It is based on the Downs opinion. Paragraphs 113 and the preceding paragraph says the Downs opinion's legal conclusions were wrong. And to that extent, that is all APA. And Judge Edwards, I'm sorry if it wasn't clear, but on page 34 of our brief, we say that the regulation that was violated in this case is the 351430, which is what I started. We're saying the government violated the regulation that Interior construed that authorized cancellation. They violated that regulation because they erroneously concluded that there were 3 statutory and regulatory violations. We also, on page 34 of our brief, and the complaint also says that the 3221.4 regulation, in paragraphs, I think it's in 113 and 114, it goes through a host of regulatory violations. On the preference right lease applications, remember that this withdrawal regulation and the statute is subject to valid existing rights. There's a lot of talk about that in the brief. And obviously, Judge Katsas, if the Forest Service had consented, there would obviously be a valid existing right, and they couldn't have done that. And so the valid existing rights are highly relevant because we think that's not a vested right. A vested right is a contract. But if there's any regulatory right to the process, i.e. we could have challenged the Forest Service's consent denial, we have a valid existing right. The notion the government said that the statute gives them the right to decline a lease.
So that would separate the 2 issues the district court conflated. Did the existence of discretion and valid existing?
Yes, the district court and the agency below. The agency never analyzed valid existing rights. It says, yeah, we have this regulation, valid existing rights, but in any event, BLM has discretion.
It makes sense to equate them if we're talking about BLM's discretion.
Yeah, I guess. Yes. I mean, we think, correct. Yes, I think we'd still have an argument if the.
Less so for the Forest Service.
Yeah, I think it would depend. We think the regulation about discretion is talking complete discretion. If you disagree with that and you think there's actually cabin discretion, then I think not only is that regulation not implicated, but the valid existing rights statutory requirement kicks in. And again, we think we are litigating our valid existing rights under the Forest Service consent issue now, which the agency sought 3 years too late. The government's entire reliance on BLM's discretion is the statutory notice that this is in the best interest of the United States, but then they can't issue an entire regulatory scheme giving you an entitlement and say, oh, never mind. I mean, that's just pretty bedrock APA law that the agency is bound by its regulation. And we think the most reasonable interpretation of the regulations is that we had a right to go through the process. And also, again, because it wasn't litigated, the government says we don't dispute the Forest Service consent. Well, we would argue the Forest Service already consented, and therefore we had a valid existing right. And that's it.
All right,
Thank you.
We'll take the matter under advisement.
Case number 21-1042 et al. Village of Morrisville, Vermont petitioner versus Federal Energy Regulatory Commission. Mr. Nolan for the petitioner, Mr. Christensen for the respondent, Ms. Murphy for the intervener.
Mr. Nolan? Morning.
Good morning, Your Honor. May it please the court, Paul Nolan, co-counsel Carolyn Elephant for petitioner, Village of Morrisville, Vermont. First, I'll address the standing issue. The issue of certification waiver is so intertwined with the relicensing of Morrisville's project that it ultimately will determine whether a license is issued at all. And if issued, it will determine what terms and conditions are included in that license, all of which affects the interests of Morrisville in continuing to operate its project for the benefit of its ratepayers and to provide renewable power to them at low costs. If there aren't any questions, I'll proceed. Okay. I'm going to make 3 points. First point is that there was a functional agreement. In fact, I would argue there are expressed agreements. The second point is that FERC's interpretation of the statute is an error. It misinterprets Section 401. And third, that waiver cannot be excused by the conduct of an applicant. The best argument or the best example of a functional agreement is actually provided by Intervenor Vermont in their brief at 7 and 8, page 7 and 8. And throughout all the briefs, we talk about a littoral habitat study. That littoral habitat study was commenced by Vermont in 2014. It was finished in August of 2015. It was transmitted to Morrisville for their consideration and for further discussions on August 14th, 2015. On August 27th, 2015, Morrisville wrote to Vermont in an email and said, over 100-page report, a lot of data, we need more time to review this. Would you agree to an extension of time? This is the second, what I call circumvention. Vermont wrote back on September 8th, 2015, said, we'll give you a limited extension of time, but you have to file something right away. In fact, you have to file it by September 9, 2015. Morning of 2015, of September 9th, 2015, Vermont emailed Morrisville to remind them that in order to have this deal done, they had to submit a second letter withdrawing and resubmitting what is referred to by Morrisville and others as a renewed application. Not a new application, a renewed application. This is the second time they've done it. They filed that letter. I went to too much explanation in the briefs about the timing and when things were done. It was accepted that same day by a separate letter from Vermont. And then Vermont turned around and took their letter and sent it to FERC to give FERC notice that there had been a withdrawn and resubmit of the previous renewed application, the one submitted on November 11th, 2014. That's an agreement. They asked us to do something, we did it, and then they actually usurped our role as the licensed applicant and went ahead and told FERC that there was no need to do anything. We're taking care of it. In fact, I'll go on to the next issue. I believe that
Well,
FERC,
FERC didn't really characterize things that way in their decision. Did
no, they did not, Your Honor. They basically said there's no functional agreement, there's no substantial evidence. We're just going to ahead and deny you your petition for a declaratory order. And
what we review isn't whether, FERC could have reasonably agreed with your view of the evidence. What we are reviewing is whether there was substantial evidence for FERC's findings or conclusion with respect to the facts, right?
correct, Your Honor, and I'm not disputing that. I'm saying that I believe that their interpretation of the record was that they picked and choose, ignored evidence that was favorable to our position, and came up with what they wanted to do. And they obviously had KEI and a few other cases going at the same time. But they did that in the face that there was an agreement, actually two agreements, to circumvent the one-year rule. If I may go on. Section 401 is clear.
Can I just ask, can you, in this case seems very different from Hoopa Valley.
Yes. Yeah, I'll explain the major difference. After Hoopa Valley, any certifying agency would have to be just impaired to enter into an express agreement. No one's doing express.
What's wrong with,
And I mean a written agreement, Your Honor, my apology.
what's wrong with a state certifying agency in an ordinary case saying they get the application, they're not sure what to do with it. They say, we need more information.
Well,
That
then what,
seems fine. You
And
could
they-
call it asking for more information. You could call it denial without prejudice.
well,
Just doesn't seem like there's anything wrong with that. And on the other side of the transaction, what's wrong with an applicant in that situation? You know, he has one or two choices: can forge ahead and force a decision within a year by the agency and then appeal that if it's unfavorable. Or the applicant can try to work with the agency and say, okay, I understand your concerns. I'm going to withdraw. I'm going to try again.
okay.
Doesn't seem manipulative or improper or to frustrate the federal licensing scheme.
I would start
What
by,
am I missing?
if I may, I would start by everyone has been acting in good faith under all those scenarios and in our own particular case. I think it was good faith. We have a village manager, not necessarily retired village manager, maybe not that sophisticated in the duality of having a FERC license going on where you basically then hand the ball off to the Vermont agency and say, you get to dribble with it for a time. But this is important, I think, and I try to make this issue. When an agency decides that it doesn't have sufficient, first of all, we know now that the clock starts to tick when they receive the application. That application is so deficient that they can't do anything with it. They should deny it with or without prejudice. If the application is okay, we can process it, but we need more information. But they can't get it in time. They should take action as required by the statute, act on the application and deny it with or without prejudice. This lets everyone know, that, and particularly the federal agency, FERC, what is going on. if I, as an applicant, say, I don't know what the hell's going on, this is not good for my project, and I withdraw the application, okay, I've stopped the 1 year clock. I'll concede that point to you. But then the question happens, what's FERC going to do? Each time in your scenario, FERC has to do something. Now, I'm not going to criticize FERC. I do that as a regular course of business. But either they're asleep at the switch or they're just negligent, because they really should have said, when in your case, this application has been denied with prejudice. FERC says, what happened? It was inadequate. Are you going to fix it? No, we're not going to fix it. All right, your license application is dismissed. We're done. Are you going to fix it? Yes, we're going to fix it. Here's what we're going to do. All right, we will permit you to resubmit and I don't want to characterize it, whether a new or revised, but it would be, in my mind, a new application with the information provided at the agent. And that's why the regs are so interesting now under the EPA, the 2023 regs, because those regs say when you dismiss something, when you deny something with or without prejudice, tell the applicant why, and they know what to fix. If I came in, I'll just reiterate it, if I came in and just withdrew my application because I didn't think it was, I wasn't going to get what I wanted, and I think that's the best way to negotiate with you, then FERC has a huge crutch in it. They can say, quit fooling around, or we're going to dismiss that application. You dismiss my application, just as Morrisville's future use of its project is in jeopardy. I have a huge investment at risk. Getting a little tongue-tied, apologize. I have a huge investment at risk. If I don't get a new license to continue to operate that project, FERC's going to tell me, surrender your license, and they may, and certainly our friends from American Whitewater here, they're going to say, and maybe you should also decommission the project by removing the dam. So we have a lot at risk here, and we're not playing games. We went and got an agreement for the first extension of time. We got an agreement for the second. Both those agreements circumvented the 1 year rule. Let's say I have 8 seconds. So let me briefly go into this whole malarkey about that I can act unilaterally for my own benefit. No, you can't. That can't be done. If I did that, as I argued earlier, then FERC would be on me for not processing in good faith my application. No one can act unilaterally. I would ask, we don't act unilaterally, and the agency didn't act unilaterally. We acted collaboratively to do this study, a study that started in 2014, went to 2015, and necessitated the second reset. I'm out of oyster and everything here.
There are no other questions. We'll give you a little bit of time on rebuttal. Let's hear
Thank you, Your Honor.
from Mr. Christensen on behalf.
Thank you, Your Honor. Matthew Christensen for Respondent, Federal Energy Regulatory Commission. May it please the court. I'd like to start with Judge Katz's hypothetical, which I don't actually think is a hypothetical here. Here, the applicant had the opportunity to proceed with its application to allow the state the full year to act that the Clean Water Act provides, and the communications that the applicant listed in the record indicate that the applicant believed that the state would act within the 1 year period, but that the state would grant the application with terms that the applicant disliked. So instead of proceeding with the application, giving the state the full year to act, the applicant, both in 2014 and in 2015, withdrew and resubmitted its application, so it had more time to negotiate with the state. In 2014, I believe the internal communications in Morrisville's own internal communications indicated that they believed the state would issue the application, but that the application would contain those conditions, the conditions along the lines that the state proposed in 2013, and that the applicant thought would be burdensome or would somehow prevent it from sort of meaningfully implementing the license. In 2015, when they withdrew and resubmitted for the second time, they said they needed additional time to consider the record. They needed to consider potential use of microturbines. They needed to consider, I believe, the flows, and then they also needed to conduct what they described as a cost-benefit analysis. If I could direct you to JA 24 and 25, this is the commission's rehearing order, paragraphs 14 to 17. The commission considered all of this evidence and concluded that both times the withdrawals and resubmittals were not done as part of the type of coordinated scheme, to use this court's language in HOOPA, to delay the issuance of the 401, but rather so for the benefit of the applicant Morrisville. I think that the evidence that the commission listed at those paragraphs, again, 14 to 17 of the rehearing order, provides substantial evidence to Judge Wilkins' question, and that's the question before the court, not whether Morrisville is correct in arguing their view of the facts, but rather the record in this proceeding provides substantial evidence in support of the commission's. And I would submit that those 4 paragraphs at JA 24 and 25 do exactly that.
Was the language in HOOPA part of the holding, or is that just really dictum as far as there needing to be some sort of agreement or working together?
So I think HOOPA was, as the Fourth Circuit described it, a narrow holding based on a fairly egregious set of facts. I think HOOPA pointed to a number of things that I think were concerning to the court, but the way in which the court resolved HOOPA, as I read it, was based on the presence of that agreement. And so the court said there are a number of, in fact, the court specifically said there are a number of questions we don't need to resolve, but an agreement that obligates a state not to act is evidence that the state failed or refused to act over the course of more than 1 year, which is sufficient for a finding of waiver under 401. So I think the direct answer to your question is, I think it was essential to the holding, but it doesn't say in full and honest candor, it's the only way a state could have failed or refused to act.
Suppose the state says, this is a very complicated application. We're not going to be able to act on it within a year. What we do in those circumstances is just, if it's really complicated, is just deny it. If you don't want that to happen, withdraw it and resubmit it. And that's what the applicant does. They're not really agreeing to anything there. They basically kind of have a gun to their head. And they don't want a denial, so they withdraw it and resubmit it. Does that trigger this provision? Does that violate the rule in HOOPA?
Well, I mean, that's obviously not this case, but I do not think that would violate the rule in HOOPA, no, because I think that's a circumstance where the state is prepared to act, and they say the act you will get is essentially a denial without prejudice, which this court's opinion in Turlock, I think, says does not cause waiver. And at that point, the applicant has a choice. The applicant can proceed and get the denial without prejudice, which is what the state indicates would follow, or the applicant can instead deny or withdraw and resubmit, thereby restarting the 1 year clock. And I think if you look at the emphasis in the statute is on the state failing or refusing to act within the 1 year period following an application. And I think in the hypothetical that you've presented, there's no failure on the part of the state to act. They're quite ready to act, but then the choice is on the applicant whether they want to move ahead and receive that decision from the state or instead withdraw and resubmit and thereby restart the 1 year clock.
What's the, HOOPA talks about frustrating the purpose of the regulatory scheme. And if the state and the applicant are in cahoots to do a seriatim withdrawal and resubmission, somehow that frustrates FERC. And I'm just having a hard time understanding that. What's your understanding? I mean, my sort of gut reaction to that is scheme is set up so that you need 3 parties to agree for a license to be granted. You want the operator to want to pursue it. You need the state to certify it, and you need FERC to certify it. And if any one of them says no, that's not frustrating the scheme. That's the scheme operating.
Yeah, I agree.
So I'm just having a hard time getting my hands around the rationale of HOOPA. And I guess the best I can come up with, tell me if you agree or not, is that when you have a scheme like that, the 1-year licenses with the old conditions just keep getting renewed and somebody, an environmental group or a tribe or whoever wants updated conditions. Is that what is driving this? Is that the concern that's driving this?
I think that could be part of the concern. I think to your point, Section 401 specifically contemplates that the licensing proceeding might not move forward at all if the state doesn't grant the certification. I think what I understood to animate the court in Hoopa was.
Sorry, go ahead.
What
I mean, if that becomes a real problem, do you have a trump, which is you can threaten not to give the 1-year renewal?
I
You can
suppose,
say this is getting ridiculous. We need 2025 conditions instead of 1975 conditions. Get your act together or we won't give you the 1-year renewal.
I think that's potentially possible. To my knowledge, the commission has never issued a threat like that. But if I can just to go back to your question about what was animating Hoopa.
Right.
I think it was the fact that 401 and the 1-year time limit existed according to the legislative history, that was put in place to prevent sheer inactivity on the part of the state. And so I think you have this 3-part licensing, this 3-actor licensing proceeding. And I think the idea of having that multi-part proceeding or that multi-participant proceeding, I'll call it, is that they'll all move forward in good faith. And that's why you can have this scheme. And if at some point, two of the 3 in that case basically said, no, we're not going to move this forward, at that point, you are frustrating the proceeding. And I think that's why Hoopa says it is the failure to act. I believe it was deliberate and contractual idleness on the part of the state. And that seems inconsistent with the spirit of 401 and with the legislative history that says the 1-year limitation is put in place to prevent sheer inactivity on the part of the state, which is exactly what we saw in that case.
How does a party like party on the other side get out of a box of the sort that they found themselves in?
You
What do
mean,
they do? What should their strategy be?
and by, just so I can understand your hypothetical, Judge, the box is that they disagree
They
with
want
the
to end up
conditions.
with a waiver because the state's not moving.
Well, respectfully, Your Honor, I think the state was prepared to move. Both withdrawals and resubmittals took place, I think, roughly 10 months after the applications were submitted. And both times, the record of the proceeding suggested that Morrisville itself believed the state would proceed with issuing the water quality certification just with conditions that it didn't like. So if that was the box, then I think the thing to do would be to proceed, get the water quality certification, and then litigate any conditions they objected to in state court, which is exactly what happened here, where Morrisville appealed Vermont's certification.
I mean, that's the answer, which I hadn't remembered the answer, at least for me, and it was challenging the state court. That's their answer.
Absolutely, and I think they vigorously pursued it all the way to the state Supreme Court, if I recall, which largely affirmed the conditions that Vermont eventually issued. No further questions?
Thank you. We'll hear from intervener.
Thank you.
Ms. Murphy, good morning.
Good morning, and may it please the court. Laura Murphy for the Vermont Agency of Natural Resources, intervener in this case. So I have 3 short points on standing. First, it is a foundational principle of standing that the injury must flow from the conduct complained of. In this case, the conduct complained of is that ANR, the Agency of Natural Resources, did not issue Morrisville's certification within 1 year of Morrisville's original request. This is the purported failure to act that is the basis of Morrisville's petition. But Morrisville does not claim any injury flowing from this alleged inaction, and in fact explicitly disclaims it. In its reply brief at page 6, quote, "The injury to Morrisville is caused by the FERC orders on review, not to any delay by Vermont." There are similar statements on page 24 of Morrisville's reply, and this morning, council also said that its standing flows from the terms and conditions of the certificate, not from any alleged inaction on the part of Vermont. Second, there is no redressability. There is nothing for the court to fix. There is no inaction that needs to be stopped. ANR issued the certification almost 8 years ago, more than 4 years before Morrisville ever sought waiver. And this is different from Hoopa Valley, where this court noted that it would not be futile to issue a waiver order because it would allow Hoopa, which was the petitioner in that case, where the application was still pending, to come back to the table at FERC.
What does it matter that they didn't seek waiver until long after the actions of A&R? I mean, their complaint, their response to your lack of standing argument is that, look, if FERC simply would just find that Vermont waived its right to, have a say in the certification, then we wouldn't have to be subject to the conditions that the state insisted upon, right? Isn't that their argument?
That's exactly their argument. And that the injury there flows from the conditions in the certification. The remedy for that injury is to go to state court, litigate the conditions, which is exactly what happened here. But they have no injury
The
from.
remedy is to say that, I mean, what's the whole point of 401? 401 has to have some legal effect.
So the point of 401 writ large is to allow states to protect water quality. The point of the waiver provision is to prevent inaction on the part of the state.
Yeah,
Sure.
but it has an impact when it's invoked by FERC, right? The impact is then to set aside any attempt by the state or any permit requirements by the state, right?
Not necessarily. So that could be an outcome. So if a state has not acted on a pending application, which is not what happened here because the application was withdrawn, if the state has not done that and a year passes, my understanding is that FERC, in the normal course may go ahead, issue the license and say, dear state, you waived your authority. We're not including your conditions. FERC could include the conditions if it wanted to.
What happened in Hoop?
I can't recall what happened. So in Hoopa, when the waiver petition was filed, the 401 application was still pending. So there was something, so it wasn't as if, so right now there's no delay, and this really gets to the redressability. There's no delay from any purported state inaction on the certification. There's nothing to fix there. That was different from Hoopa Valley. And with respect to the injury that needs to be present for a waiver petition, this court's case in Weaver's Cove is on point because it was very clear that to have standing for waiver under 401, the injury must flow from the alleged state inaction. And the court said the applicant here hasn't claimed any injury from the inaction, and that's exactly what we have here. And just quickly on the issue of Morrisville saying, well, we're aggrieved by FERC's order because if we have waiver, we don't have to comply with the conditions. In Hydro Investors, also from this court, and Wilcox from the 8th Circuit, those cases were very clear that to come to court, the petitioner needs to have standing for the relief it sought before the agency. So though that is the relevant standing inquiry, was there injury from inaction, and is any alleged inaction redressable? And it's not because there's no inaction to stop. Morrisville should not be allowed to bootstrap its way into court. And more generally, applicants should not be able to game the system in this way. We respectfully ask the court to dismiss for lack of standing.
So when would an applicant be able to base standing on FERC's improper interpretation of Section 401?
If there's still a 401 application pending, let's say there's a pending application, the state hasn't done anything, let's say for 5 years, or let's just say for 1.5 years. And the applicant goes to FERC and says, or even doesn't go to FERC, and goes to FERC and says, please declare waiver, and FERC says no. The application is still pending. There's still delay that needs to be fixed. I think it's safe to say the applicant would have standing under those circumstances. But where, as Morrisville has conceded, it's not claiming any injury from delay. There is none. And again, coming back to this redressability point, if there's been a certification that's already been issued, there's nothing to fix under the failure to act
So if
provision.
the state takes a year and a day to act on an application and they impose conditions that an applicant doesn't like, and the applicant goes to FERC and says, well, under 401, their certification and their conditions are void. So set those aside. You're saying they wouldn't have standing because at that point, FERC can't redress any delay?
They wouldn't have Article 3 standing. That's correct. Now, whether FERC could still decide it, I think is a separate question, but they wouldn't have Article 3 standing to pursue that remedy in court.
All right, I understand your position. All right, thank you.
Thank you.
All right, Mr. Nolan, I think you're out of time, but we'll give you 2 minutes.
Neither FERC nor Vermont are entitled to deference. The EPA speaks. The EPA has spoken twice, 2020 and 2023, when it implemented regulations that specifically said under Section 401 what actions are required: grant, deny, or expressly waive. Morrisville went to FERC and said Vermont didn't take any of those actions. Therefore, under 401, their certification authority is deemed waived. We can talk about the terms and conditions. Those were litigated at the court, state court, as properly. But our issue here and our injury here is that they actually had no authority to do anything. We went to FERC, asked them to declare that. FERC refused to do that, came up with, well, that's, even though the statute doesn't say that withdraw and resubmit is not okay, we think it's okay. We think it's okay when it's done for unilateral action and your mutual benefit, whatever that really means in this circumstance. But I want to address one point that you raised, is that the FERC now says the reasonable period of time, no matter what, for any application, 1 kilowatt, 100 megawatt hydro project is now 1 year. And therefore they've now said, okay, it's always 1 year. We don't know until an application is, 401 application is actually filed with the state, how much will be involved. The bright line that we asked for is that you submit an application, we know it starts. That's the technique of analysis, I argue. Then we decide, has a year lapsed? And if a year has lapsed, then their certification authority is waived under the statute. If it hasn't lapsed and for some reason we withdrew and resubmitted because we thought, we could cut off the 1 year period, as you heard FERC's attorney say, that's not what went on in this proceeding. We were told we had to file by September 9. Why did we have to file by September 9, 2015? It's because the state said they needed time to issue the notice, to have the hearing, and issue a 401. Thank you.
Thank you. We'll take the matter under advisement.
This honorable court now stands adjourned until Tuesday, January 14th, 1:30 a.m.